everybody. I'm glad everybody's doing great today. Chuck Cook, Aaron Hall, Greg Siskin. It's great to be here. Guys, Greg, you got nice, warm, terrible weather in Memphis. And Aaron, is it snowing?
Greg was just.
If I have to run out of the room, it's because we're in a tornado warning.
Yeah, it's 2 degrees here, and the snow's coming down. So yeah, it's cold.
Well, I'm in the happy medium. It's about 50 and slightly drizzly. That's what today is. So, it could be worse. It could be worse. So, guys, we've had a really kind of eventful week since last time. We did get on Friday. Was it Friday or yesterday? Yesterday, we've got the DV 2022 case file. So let's go with the banners here, so I don't get Lily mad at me.
As a name.
Yeah. And the name of our case, Aaron, is
Boo Jabor.
Boo Jabor.
Yeah.
All right. It's not good luck, but it's pretty darn good. Boo Jabor. And so we filed that we chose to file this in Washington, D.C., because we think there's really good case law there that helps us. There's good precedent law there. And Aaron, we got a surprise today when it was assigned to a judge.
Yeah. So under the local rules, the case can't technically be related to another case if the first case isn't still pending with the district court on the merits. And so the cases of Gomez and Go are not technically pending on the merits with Judge Mehta. And so we couldn't file it as a related case. So it got put in for random assignment to one of the judges at the district court in the District of Columbia. And lo and behold, this morning, we find out it's randomly assigned to Judge Mehta. So he's familiar with us. He's familiar with the DV program and what's happened over the last few years. And he's not going to need a lot of history lessons about it, which is a good thing.
It's going to make oral argument a lot of fun in this case. So we're now, Aaron, where are we now? What is the next step in this case? Obviously, we can add plaintiffs for the next 21 days, but what is the short-term goal here?
Yeah. So when you file a lawsuit, the government has 60 days to file an answer. But we don't just sit there and wait for 60 days for the government to file an answer. In the coming days, we'll see if somebody enters their appearance. They may not, but either way, we'll reach out to try to start to talk to them about an expedited briefing schedule and an expedited production of an administrative record. And based on that, that's where we make our decisions about whether it makes sense to seek a preliminary injunction or just go straight to summary judgment as we did in Go. And so those are the next steps here in the coming weeks.
What makes this case a little bit different than Go is it's filed in February. Now, instead of, last year we actually did file in November, and then the judge basically thought that Biden was going to fix everything, so he dismissed it. And then, of course, we had to refile the case. This is February. We have some interesting factoids in the DV 2022 litigation. Aaron, how many cases they approved as of the day of filing?
Oh, there were 2,000, according to the SEAC statistics, I think 2,400, something about that, a little bit more. 2,400,
which we calculated to be somewhere in the neighborhood of like 4% of the visas. And there are now almost 40% through the fiscal year. So you're at 10% of where you should be. And that's not bueno, as I say in the old country. It's not bueno. What helps us with Judge Mehta, though, is that even though we don't necessarily agree with his formula, he likes to look at immediate relatives. Well, what are you doing on immediate relatives? And immediate relatives are beyond pre-pandemic levels at this point. They're going gangbusters. Now, everybody knows that they're doing that probably because they're ignoring everything else. It's not just DV that's being ignored, although DV is clearly being ignored. But F2 family-based, F2A, F2B, F3, F4s, F1s, sitting out in the never world. So we don't have litigation on that yet, but I'm just telling you, it's a problem.
Now that's true, but I will say that immediate relatives, as you said, are on pace to go way above the last pre-pandemic year. But total immigrant visas are at, I think we calculated they're on pace for about 90% of fiscal year 2019. So as a whole, they're in pretty good shape. They're processing a lot of visas.
Except for
just
DVs.
not DVs. Yeah.
And if they were doing DVs, they would be at 100% probably.
And we still haven't, we're now at the 2-year anniversary of this whole stuff mess starting, but we still haven't gotten anything from the State Department regarding their plan for getting at least back to the level that they were at in March 2022, much less what new changes that they've made to their processing to try and be able to handle a larger volume to catch up. I mean, we don't have the plan for that yet. The USCIS, at least on their side of things, with that plan that they just report that they just sent regarding e-filing, they seem to have an idea of like how they're going to try and catch up and get normal processing times for all types of processes down the road. But we haven't seen that from the State Department yet.
It's wild because one piece of what could have been a plan was implemented. They tried to get rid of the bottleneck at KCC by saying you don't have to submit documents for DV 2022. You just have to submit your DS-260. That should, in theory, have helped, but it's not translating.
I was looking back at the DV 2020 numbers prior to the shutting down of the consulates on March 20th, 2020. They had only issued, I think, 13,000. The Trump administration was intentionally slow walking DV 2020 anyway. This, of course, gave them the reason to do that. You would think under Biden, they would at least be at the slow walking level of the Trump administration, but they're just not there. So we're working on serving the government. Service takes what, a couple days, Aaron?
Yeah, we're waiting on the summonses from the court, which I would guess we'll get today, and then we can get service accomplished this week.
Great, that's wonderful news. That's where we are. Greg, do we have a waiting list, people that might want to join the DV 2022 litigation?
Yeah, we do, and we actually have had quite a few people since yesterday, since filing, that have signed up for that. There it is. Okay, write that down.
Or click the link. I don't know if you click the link or not in the video, but if you got, I guess if you had a mouse, you could do that. But it's not the best waiting list email address, but it's good enough.
Yeah, sorry.
We need to get it on our Impact Litigation website. That would be a lot easier for us. But that's good. So go in and you can join that suit.
I'm going to work on an alias so we can have an easier.
That would be good. That would be good. So that's where we are in that litigation. Let's take a look. The other thing is the Kang case. Aaron, what's going on in the Kang case?
Yeah, so I guess somewhat predictably, what the government did, which is great for our plaintiffs, we're very happy for them, is that they adjudicated all of the EAD applications for plaintiffs. And the reason that they did that was to try to moot out the case, and they've notified the court that they've done that. But we filed this as a class action for a reason, and it's because just mooting this out doesn't solve the problem. It's a problem that's going to repeat and repeat and repeat and evade litigation if the court doesn't address it as a class. And so while the government's saying, just dismiss the whole case now, we're good. We have a response due today that deals with that. It's a response to their motion to stay briefing on class certification. And we will deal with that argument there and explain why. No, we need to get the class certification fully briefed. We've briefed our side. We need a response from the government, and we need a decision on it, because once it's certified as a class, if it is, then we can move forward, notwithstanding the fact that they've adjudicated plaintiffs' EAD applications.
They did try to use a little sneaky half quote from us in a notice to the court, didn't they?
Yeah, they did.
Yeah, that was a little sneaky. Well, they agreed to dismiss the plaintiffs. Okay, but not the case. That's a different thing, government. But I had a very interesting conversation last week with a member of the folks that work at Department of Justice Immigration Litigation and the U.S. Attorney's Office. They are essentially under orders to file a motion to dismiss in every case. Punto. That's their position. Motion to dismiss in every case. So that's been confirmed. And they said we got that order last year. So in the Biden administration, they were told to file a motion to dismiss in every case. So normally we would just like ask for continuance on the answer and deal with the problem, but they now want us to file it in every single case. So, that means that we will move forward more aggressively on TROs on these cases where they haven't filed a motion to dismiss yet, because it kind of takes them out of their game at that point when they have to deal with that. So that's the EAD case. It's called the Kang case. We will keep you updated. We will post on the Twitter machine our redacted brief later today, and we'll go from there. The next case is the H-1B litigation. Let me see if I can find the H-1B lottery abuse case. So we filed everything. Everything's into the court. Yesterday, however, apparently USCIS announced that they are beginning to allow employers to create their identity within the registration system so that on March 1st they can register. Aaron, I don't recall that happening last year. Do you guys recall that last year? I have no recollection of that last year. I thought it was just like registration March 1. So we are debating whether to bring that to the attention of Judge McFadden in our case and say, hey, Judge, we know that you're aware that we would like a decision by 2/28. Just FYI, the government's pretending this litigation doesn't exist or doing this. I just haven't. I mean, guys, what do you think? I haven't decided to do that yet. We'll have to think about that. Put the thinking noggin on. But I think I think that by Monday we will have a decision. I really do believe that by Monday we'll have a decision in that case. Either way. So that's why I'm kind of hesitating whether I should, do anything. I think the judge is clearly aware of what's going on. If it comes out on Friday, now don't all decisions come out on Friday afternoon at 5:00? Isn't that when all judges make decisions? Sure seems like. I hope that's not the case. If it is, well, then we'll probably do a live for our lottery abuse folks and let them know. But we remain confident. I remain confident. I think it's a good case. Do we have any updates on our either Go or Gomez cases? We filed in Go. We filed our opposition. We did not file anything in the Acker case when we have two families that are plaintiffs. But it's really the Acker case consolidated with Gomez, so there wasn't a need for a separate. I mean, the judge is going to read the same thing 3 times. I don't think it's necessary. So that's why we did not file a separate opposition in the Gomez Acker case. I thought the Gomez folks did an excellent job getting their point across. I thought Curtis did a great job getting his point across, including a couple of very nice, snarky comments, which I really always appreciate. Thank you, Curtis. And
we love Curtis.
I thought you guys did a good job on that. So we'll see what the judge does. The government now has time to reply. Now, here's what's interesting. So we filed that, what was it, last week or sometime last week. They didn't file an immediate reply, did they? I mean, it's so urgent to them. It's so important, so vital that they stopped the case, but they didn't file an immediate reply. That kind of speaks volumes, I think, about how their urgency really doesn't exist. That's not going to go lost on Judge Maida when he gets to that case. It's just not. They also have not followed through on their threat to go to the Court of Appeals, have they? No, they didn't. I think that would not go over well at the Court of Appeals. Should they try to do an interim stay while the case is still pending in front of the judge, especially after his minute order that we talked about last week. So that's kind of where we are on Go and Gomez. On the K cases, we talked about this last week. This is for the Manila case. We are putting together. The judge asked for an update by March 3rd. We're probably going to do that earlier. Is the goal. Lily's gathering the information from all the plaintiffs. So any of the plaintiffs on the cases, and we may just duplicate that, even though not asked for in the other cases, duplicated in all 4. Say in a related case on a similar issue, the judge asked for an update. Here it is. The government, oddly enough, has not reached out in that case to say, should we jointly file something? But we'll go ahead and get that filed and probably do that this week. Okay. So that's kind of where we are. Now, we do have, Greg, do you want to talk about that other thing we're talking about?
EB-5?
Yes, our EB-5 litigation.
Yeah, so happy to. We actually put out an FAQ this morning and are about to set up onboarding for a case relating to EB-5. And it's an interesting case because the EB-5 program has been in some turmoil over the last year because a section of the statute regarding regional centers has expired. USCIS and the State Department have taken the position that what's expired is the whole regional center program. But a lot of lawyers that are looking at this issue, including us, and which is the reason why we're filing this litigation, believe that it only affects the part of the statute that reserves 30% of EB-5 visas for regional centers, and the rest of the numbers are available to those applicants. Now, that's really important because the rest of those numbers are not used that often. There aren't that many regular EB-5 filings that are out there. So USCIS and the State Department should be adjudicating I-526s. They should be approving adjustments of status. They should be approving immigrant visas at consulates for people that are filed DS-260s. And all of that's been on hold. And what's prompting this litigation right now is congressional offices were just notified by USCIS, which is sitting on all of these applications, waiting on Congress to extend this deadline, which they think is an extension of the whole program. And we think it's just an extension of this one little piece of it. But they're now threatening to deny all applications beginning March 11th. And these are people, that have filed these applications that have spent a lot of money on filing these applications. They've tied up sometimes their life savings for several years waiting on these applications to be adjudicated. And we are filing this litigation. It's basically, it's a little bit complicated as far as what it's doing, but first we're going to seek a declaration from a judge that the law is the way we the way we believe it is, not the way USCIS has been interpreting it, the way I just explained. Second, if we're successful on that, or if Congress does get around to extending this program, we will move it forward as a mandamus action for all of those plaintiffs who have been waiting, like most of them, years on those cases. And then if we lose, we will also seek to get to force the agencies to refund filing fees on there, which at a minimum, it would give an incentive for make these agencies think at least about sitting on these cases versus denying them, and what's a better use of their resources and their time at this point. So that's what this case is about. The FAQ is done. We're working on an engagement letter app, which will be ready today. And the web page for this will be ready today. So there's probably not that many of those folks on the call right now that are in EB-5, but some of you may be watching the recording of this when you hear about this case and when we start posting on it. But that's something to be on the lookout for later today. One other important thing about this is we have co-counsel on this case. We don't usually bring in lawyers from other firms on this, but Matt Galati, who is Philadelphia / Southern Spain. He kind of is dual residence. Matt is an EB-5 guru, thinks about EB-5 from morning to night. And he also has litigation experience. He's joining us on this case. As we are speaking, he set up a Telegram group that for EB-5 folks, and I'm getting pinged multiple times since this call started. About that, but Matt's going to be invaluable in this case, and we will probably be doing a separate live stream about this soon. Stay tuned for more information.
Okay, so we'll get that link up and take a look at. If you're an EB-5 beneficiary waiting for forever for your adjustment, immigration's about to give you the royal screw job. Just FYI, and keep your money. And keep your money. That's what they're going to do. They're going to deny us. Thank you very much for loaning us this money. We're going to keep it now. Have a nice day. I think that's illegal. I think it's illegal to do that. But what's really frustrating about these cases to me, and I think, Greg, I have clients in this exact situation, is they entered the program in good faith. And USCIS is taking the most narrow, I think unlawful interpretation, but certainly the most narrow interpretation of the language of the statute. And for what reason, I don't know. I just don't get it.
Well, the other thing that's frustrating is USCIS put these people in this situation by delaying things so much and then taking the position that this program expired. If they would have done the processing in a normal time frame, all these people would have had their visas already. So it's like they're being punished twice by USCIS, once with the initial slow processing and second with this illegal interpretation of the statute.
Well, it's really frustrating. I have one client, unfortunately, from Brazil, who was scheduled for their Department of State. They were processing in Brazil, had completed processing early last year, and the embassy was closed. Right, they weren't doing EB-5s. Begged. Embassies set their appointment intentionally 2 days after the program expired. There was literally no reason for them to have delayed, and then they made them travel to this consulate to have an interview that they knew they could not approve. If you don't come, we're just going to deny your case. I mean, it's monumentally frustrating. So there we go with the actions that are going on. And we'll, of course, keep everybody updated about everything else that's happening out there. We got some comments here. Osama, good to see you. When will the April interviews start? And I think he's talking about the April visa bulletin interviews. I think he's thinking DV 2021 because, of course, Aaron, all the 2022 cases have been front loaded. So they all done before April 1. They're all done before April 1. That must be what he's thinking of, right?
Yeah. No, Osama, assuming you're referring to the reserved visas that have to be issued this year from 2020 and 2021. They said that they could not start before April. And now they are, I'm assuming they're waiting for a decision on their efforts to get the whole order stayed. So
they did note in other litigation that their system will be fixed in order to issue these visas on April 17th, I believe, is when they can use the system to issue the visas appropriately for the right year. So certainly not before April 17th. I do know, I know they're scheduling DV 2022 cases still, I think. I mean, Britt's really the expert on that, and you can ask Britt about that. But I think that they are slow walking this on purpose, and we're going to find out why. Aaron, when you went through this, because Aaron literally went through the statistics page by page. There were some consulates that have done none, right? That just have done none.
Yeah, Sydney, for example, hasn't done any.
None.
Yeah.
None. And at Sydney, Australia's open again. You can go to Sydney. None.
There was some news from the Hill this week. I don't know if you want me to mention anything about that.
So what is the most recent get your false hopes up news from the Hill this week, Greg?
It's always false hopes. So it's actually this week's news is, I think I talked about America Competes last time, but this time there's actually some encouraging news for doctors. And even though that's probably not too many people on this call, it's really important, I think, that Congress pass at least one immigration bill just to get the ball rolling and be able to start getting it back into the habit of passing legislation again. We haven't had an immigration bill pass in this country in 18 years on there, except for the premium processing, which is not really an immigration bill. This doesn't change anything about the immigration system on there. But in terms of actually things that affect visa processing and real substantive changes, we haven't seen anything in a generation. So the big news this week was Senator Durbin is the lead Democratic co-sponsor of a bill called the Healthcare Workforce Resilience Act. And even though it's about doctors and nurses, it has an indirect but very important impact on all Indians on there, because 40,000 green cards are pulled out of this recapture concept, where numbers that weren't used in previous years, they allowed those numbers to be counted now on there. So 15,000 doctors, which is a number that when we were consulted about this legislation a long time ago, that's a number that we thought would get rid of the backlog entirely for doctors, and 25,000 nurses. And importantly, all their family members' derivatives are in this program as well. So we think that adds another 50 to 60,000 people. So we're talking about 100,000 green cards that will be taken out of a line for everybody else once this happens. And unlike the rollovers and things like that, this is like permanently taking it out. If they don't use the numbers up this year, they will continue drawing on this number next year and the year after. Now, the reason why I'm more optimistic about this bill is that there's something unique about it. And that is this week they announced 14 new co-sponsors in 1 week, 7 of whom were Republicans. They already had 7 Republican co-sponsors on this. And what I've said in the past is any legislation that has at least 10 Republican co-sponsors on it is in a different ballpark than any other immigration legislation because of the filibuster. They have enough votes from the Republicans, assuming that the Democrats vote for this uniformly, which they should, on there, especially since Senator Durbin is a co-sponsor. They have enough votes to pass this in the Senate. The House has 65 co-sponsors, and about 10 of those are Republicans right now on there. So they have the votes in Congress to pass this legislation, and Joe Biden will sign it. He's not going to veto this. Now the question is, well, wouldn't you bring this up immediately if you have the votes for it? And apparently I've gotten through back channels some cold water thrown on that. It's not that simple, blah, blah, blah. What I think is going on, and this is what's super frustrating to me, and probably Chuck will, because he knows this is probably what's going on as well, is there are some that where the perfect is always the enemy of the good with immigration. That there are people out there, if you don't fix every problem with immigration, then we're not going to support your legislation, even if it's moving you in the right direction. And I think there may be some of that going on right now with DREAM legislation and some others that are really important bills that need to happen. But there's this linking that happens sometimes. I don't know that that's what is happening, but I have this suspicion that there might be some of that going on. So if this legislation it starts to appear that is being slow walked for some reason and there's no apparent explanation for it, that would probably be my suspicion for why that might be the case. I don't know, but I do want folks who are interested in this issue. We're starting to have some meetings with some of the interest groups to start an advocacy campaign. So look for more on that soon. But taking 100,000 people out of green card backlog lines would be tremendously beneficial, even if you're not a doctor or a nurse.
2 things on that. I actually did see somebody whining about that, saying, why doesn't it include DACA kids? Yeah. I've already seen that article. There's actually a note in something I was reading this morning. But Greg, this actually gets me to the other thing I want to ask you about. USCIS came out this week, because this goes to our Chakrabarty litigation. And they previously said, we're going to use all 380,000 EBs. This week they said, hey, people, you need to be applying for EB1s and EB2s because we're not going to use all those numbers. And I was thinking to myself, do they read the same statute that I read? Are they insinuating that because there aren't 40,000 EB1s and EB2s, they won't be used by EB3s? This is bananas to me. I'd like to get your take on this truly.
I don't have a take on that. I saw that and I was like, what are you people doing? I don't know what they're, what it seems like they're playing games, and I don't have a good answer.
I mean, that may romp into litigation later this summer, because it makes no sense. Even David Beer of Cato, who's a brilliant immigration policy guy, he's like, I don't understand. I love David because he's very honest. I don't understand what they're doing here. Don't these visas just drop down to each category each year and you get to use them? I know the initial statement from CIS was, hey, if you're an EB3, but you're also EB2, but your most recent thing is EB3, you should do a supplement J and do an EB2. Except all these supplement Js have gone in and nobody's gotten a receipt notice on any of the supplement Js they've filed. So nobody knows how many they have. So it seems like they're intentionally, unintentionally complicating the process, because we do know this there's only about just a little under 310,000 pending adjustments for EB cases right now.
Yeah. I mean, really what they should have just said is, if you have a qualified application in either category and you're a current, we are going to do everything possible to make sure that we maximize the number of green cards that are being used. So, I mean, that's all they needed to say, is that we are going to, you need to make sure that you are eligible for processing in any category that's current, and we are going to do our best to adjudicate all of those applications so that whichever category you're in, you will get the benefit of a green card. If we're able to get that done.
Well, the thing that strikes me as strange, though, is they don't appear to have enough pending adjustment applications to use the numbers that they have. They have more numbers according to their most recent stats. Now they're behind on their stats, but looking at pending EB adjustments.
Well, then they need to change the bulletin. And
exactly. So why is the bulletin not?
They need to invite more. I mean, they need to move it forward. If that's ever happening, they need to move it forward. And that's the other thing. It's like, what is the harm to the public? What is the harm if you are, if you guess wrong, and you have too many coming in? You have people that get the benefit of portability, get the benefit of an EAD, get the benefit of travel documents. It's like, there's no, if you can in good faith accept more, the maximum, and take on the broad end, take a larger number of applicants, you should be doing that as an agency. You should always be defaulting to taking more, not less.
USCIS has not released their first quarter number. So the most recent adjustment of status numbers we have are from year end 2021. So we've got the numbers of pending cases. They say, I'm looking at it right here, there are 245,490 pending adjustment of status cases. Now, remember, there was a cutoff in October, right? The retrogressed, all that stuff. So they wouldn't have been getting certainly any of the old Indian or Chinese cases. So obviously there have been new EB1s, new non-India Chinese have filed, right? We get that.
Right.
But they had 380,000 visas to use. And they
so
only
think the ones that were still pending, the ones that were filed last year, plus the new ones, is still less than the inventory of it.
It has to be, because remember, they got the big, I don't know, maybe 100,000 applications got filed. And okay, well, where are they? I mean, our clients don't even get their EIDs yet from the stuff that was filed last year. We know they're in the system. They have 240,190 as of September 31st. So how are they going to use 100,000 if they don't move the visa bulletin forward? Now, that said, this is a great opportunity. If you're not Indian and Chinese and an employer sponsors you, I mean, you're going to get a green card, in just whatever the processing time is. So we're all old enough to remember, at least I am, when EB3 was backlogged worldwide for 10 years. So we're old enough to remember that. And if they would just move the number forward, you got probably 100,000 Indians that could file tomorrow. And they could, literally this year, they can cut the backlog by 60%. Like that for Indians, like that. It's just really frustrating to me. We will talk more about this as we get more numbers from CIS, but there may be some more Chakrabarti-like litigation coming down the pike that will not be filed in Maryland. That's part of it. All right, got more questions. Brett is our last remaining. He's our last guy. He's our last EAD guy. So if not for this list, I would have been waiting a lot longer. I agree. So we filed this about 3 months ago, and all of our clients got their EADs.
Right. So you talked a little bit earlier, but it might be worth repeating about, that we're hoping that this is not the end of the case that on there. If we lose on that issue, though,
we're going to come back and refile.
And we will file another suit for for people again. So that's, obviously this was a good result for our plaintiffs on there, but the hope is that we can get something bigger for the rest of the universe of the backlog DAD.
This is not the end. If he tosses this on this ground, we will the thing is, we will file immediately class certification, preliminary injunction. We're going to drop it all. If this is the game they want to play, it's kind of stupid, because look, if you dismiss it, great. We'll be back next week with another 100, 200,000 cases, because I don't know about you guys, But my mailroom is not full of envelopes that have EADs in them.
No.
They're not. I mean, it's just crazy. Super Ambus Bemis. Can we come to the U.S. for U.S. if judge made it denies the defendant's lawyers to stay? Go plaintiffs. Again, this is not an answer that we have yet. State Department has ignored Curtis's request. Curtis made a formal request to them. They've ignored it. There is no formal motion that I'm aware of pending with the judge about whether his order means that if you are a DV 2021 winner, you can come in and adjust status. So my advice is don't do that because we don't know. Now, if you are a DV 2022 person and you have a visitor visa in the United States and you decide that March 1 would be a good time to go to Disneyland and you end up staying longer than, say, I don't know, 60 days and say, you know what, maybe I'll just adjust status here. Perfect.
You know what's interesting about this question, though, is like when we were talking about sort of like the big plans that DOS could have for actually working through their hundreds of thousands of backlog cases, probably closer to 1 million at this point, they could put together a plan with the Immigration Service and parole in a big chunk of those people and let them file for adjustment of status cases coming in on in a parole status if they have a visa number immediately available to them, and they could instantly cut their workloads dramatically at these consulates if they worked out something coordinated by the White House on there. It's not it may seem like a really far-fetched thing to do, but they're in an unprecedented situation, and this would be a pretty good solution to get people into the U.S. and getting the benefits of their green card applications, even if they don't have a green card right away.
If you're old enough to recall, or you teach the history of immigration law like I do, the adjustment process was created to take the burden off the Department of State of issuing every single immigrant visa. Prior to 1952, every immigrant visa had to be issued at a consulate. There was no adjustment of status. So, I mean, this is something that technically can be changed. I mean, literally by the president signing an order, I think. 29 Super C. I need to go on the BBB. The BBB is quite dead. And I think Greg did a good job of summarizing what is out there on this. Team Gab, what do you think the chances of the K-1 visas also getting expedited processing? I mean, they're not expediting anything. But if the judge rules on the motion to dismiss and sustains our position and the cases move forward, I think they would all be adjudicated right away. So any opportunity to join the DV 2022? Yes, there is. You go to this link right here. Greg put a really great shortened link up here. Let me find it. I'm going to copy that link address and make a new banner and stick that up. So this is the link. If you want to, hold on.
It's just a bit.ly link. All you have to do is just write down the last 6 digits.
So there you go. You want to join the DV 2022 lawsuit? There you go. You sign up right there. We'd love to have you. Frostman thought the use of the word front-loaded was good. Thank you for the update. Looking forward to the decision. Yes, this is for our H-1B litigation. We do too. And the last one. Do you have any idea how family-based spillover DVs divided between India and China? You know, here is my understanding, and Greg and Aaron, maybe you guys can correct me on that. I think it's the numbers come over, and they start at the top, and they start with the oldest cases. So my guess is that those spillover numbers basically go almost all to Indians because their prior date is so much earlier than everybody else's. I mean, even it's 6 years earlier than China. So I would suspect that they go to the oldest cases first, and then they work their way through that. Greg?
I thought that, well, I mean, maybe effectively the same thing, but I thought what happens is that when they go, when they spill back over, they go to the category, and then it basically goes through the formula as far as the, I mean, yes, to the oldest cases first, but it's it will still have the same, be subject to the same country caps after. I mean, so if they're, well, that's a good question. But I
call Charlie Oppenheim right now. Charlie, what's the answer to this question?
Is he like a private consultant now? What's he doing? Or is he totally?
I don't know. My understanding though is the numbers are not subject to the standard 40-40-40-10-10 formula. they're unrestricted within the EB category, is my understanding. And that's why they should dump to the oldest case first. And of course, we all know USCIS is strictly first in, first out. I mean, we know that, right? That's a lie. But that's what they're supposed to be doing. Team Gad, we asked earlier about expedited K1s. You may ask for help. Greg, you guys do consults. We do consults every day with people. I want to do a fiancé visa. And my question to them is, where do you want to get married? Because K1s, depending on what country you're in, are going to take longer than just going and get married and doing the green card, because they clearly are prioritizing immediate relatives.
Get on a plane, file for consular process.
I'm just not a huge fan of the whole. I know they made a TV show about it, okay, but I'm not a big fan of the K1. I mean, the actual process, because of what we're seeing here. They have to prioritize, and then they do this technically. Citizen, spouse.
In the before times, the K1 was good.
Yeah, before right now, I don't know. Joe Puccini, you discussed favorite. Yes, we talked about that earlier. For all our friends in the Ukraine, we have clients in the Ukraine. There is a special rule, by the way, Biden administration just announced. If you have a valid visa, get on a plane now. Just come. Just come. We have a client was waiting for an E2 renewal, putting on a plane with her visitor visa and her 2 U.S. citizen kids. You have 2 citizen kids, and they're getting out. So if you've got U.S. citizen
I would
children,
get here now, because I think in the next couple of days they're going to have TPS for Ukraine.
Yeah, I would just get here. I think the TPS is going to be
automatic. Here, if you can get to the U.S. immediately and the TPS is offered, it's going to be based on who was here before that date.
Yeah. So you want to get here. If you're from the Ukraine, you got a visa, get on a freaking airplane if you can. Get over here.
Yeah.
This same thing happened, although not for the same reason, when the Argentinian money, I think it was the peso, back in 2000, and they collapsed. Their economies collapsed like overnight, and they had the visa waiver back in the day, and everybody's like, "Get to the United States." This is a little bit different. They didn't get TPS, but I think Ukraine would get TPS in a heartbeat.
Yeah.
Can you get Charlie on the call? One day we should invite Charlie on.
I just got a text that Charlie is in a meeting right now with Matt Galati.
Oh,
talking about EB5 stuff with some group, but
well, there you go.
He is still at it.
Our last question: can USCIS be sued for encouraging downgrading and upgrading from EB5? First of all, it didn't technically. You didn't have, and really until this year, there was really no encouragement from USCIS to downgrade. That was like, hey, the whale's on that side of the ship, and everybody runs to that side of the ship and looks at the whale. Now they're on the other side. They switch back. It was not USCIS. Now they're doing it, but they didn't previously. And I agree, it is a massive waste of resources for USCIS to be doing this.
No, all the money is being made on EADs. We know that.
Well, but actually, I think INS is they're getting screwed on the EADs because they can't charge for the EADs. With the adjustment, with the EAD included in the adjustment these days, so they're getting really screwed on this. Just crazy stuff. All right, everybody, it is good to see everybody. We will be back next Monday. Who's live tomorrow? Is that you, Aaron? Are you live tomorrow?
We're Thursdays, but we are taking a week off. We'll be back next Thursday.
I'll be live tomorrow at 5 o'clock on my Facebook channel. Greg, when are you live?
I'm going to be on for about 20 or 30 minutes this afternoon, but I'm working on this EB5 stuff, so I can't stay on that long.
As am I. All right. You guys have a great week. Talk to you later.